Go to the 8:15 review calendar. Desiree Edwards is the first one. Ms. Edwards, come on up and have a seat. Good to see you. You filed and I've reviewed the assessment. That was just filed. That was the ink's dry.
Yeah,
How are you doing?
I'm good.
And according to boy, this is about a comprehensive assessment as I've seen in a long time. It looks like their recommendations are based upon where you are in life right now is to do an impact panel, which you've done, and do drug and alcohol information school, ADIS. It's an 8-hour program. Do you know how long it's going to take you to get that done?
Maybe like a month or two. I'd say 2 months.
How about 2 months?
Okay. Yeah, I gotta save for it.
Mr. Radfield, what I'm inclined to do, based on the assessment, is give Ms. Edwards a couple of months to get that done. We're going to give you another court date. Desiree, that's September, October. About October 24th. October 24th.
Okay, thank you.
Now I'm going to sign an order to that effect. With this understanding, if we have on file proof that you've done that you don't need to appear and listen
Okay.
to me.
All right.
That might be the best thing, not having to
Yeah.
listen to me. But hey, no, you look good, and it sounds like life has improved quite a bit since 2020.
Definitely.
But hey, we're still here, and you're doing well, and yeah, just one more hoop to jump through, and that's it. Any questions of me at all?
No.
Life going okay?
Yeah.
You tell me a little bit about it here, but there's always a lot between the lines. But you look healthy, you look well, and that is good to see. I want you to stop at the window on the way out, get a copy of today's order. It has the court date on it. And again, if you do the school,
I'll do it.
and you're not planning on attending, make sure, give us a call and a couple of days ahead of time, just to make sure everything's okay.
I will. Thank you.
Ms. Edwards, thank you for appearing. Thank you for your patience, and thanks for everything you've done. Mr. Elisara does not appear yet, I'm hoping. Mr. Higgins. Tim Higgins. Mr. Higgins, good afternoon. Good morning. How are you? It looks like.
Did you get the email with
Discharge summary? It looks like you're in the same situation with county.
Yeah.
The reason.
You got the updated one?
Pardon?
You got the newer one, the updated one finally?
Could you speak up?
You got the updated one finally? All right, I was
This-
just making sure that that came through.
This is a discharge summary. It says that the reason for discharge is you're changing the program type or provider. Is that true? Are you going to a different program?
Yeah, starting tomorrow, I'm going up to Northwest Resources.
You have an appointment, you're starting classes?
Yeah, I have an appointment at 9 o'clock in the morning.
And that's with what agency?
Northwest Resources.
Is that going to keep the county happy as well?
Yeah. Probation's waiting for me to start that.
You're on county probation. I'm aware of that. They have much sharper teeth than we do, shall I put it that way. So what you want to do is make sure you remain in compliance. You know, people change treatment providers for a number of reasons. I hope yours is one of the good reasons instead of one of the bad ones. Why don't you're starting tomorrow. Why don't we set this out the September 26th And if we have a compliance, report on file by that date, you don't need to appear.
All
I'd
right.
rather have you spend your time in treatment and getting on with life. Now, I don't have any. Is there something you can file showing that you have started with? Are they gonna reassess you?
Yeah, they're gonna have to reassess me, reintake me and stuff. I don't have anything for a appointment. I just called them over the phone and made it.
Mr. Higgins, as long as, this is something that's gotta be done, you know, that's apparently for not just us, but for the county as well. We'll reset it, with the understanding that if we get a compliance report, shortly before your next court date, you don't have to show up. How is life going otherwise?
Pretty good. The little one's standing up.
Hey,
Should be running in no
you're
time.
vertical, taking nourishment, you're doing well, that's the important thing. I'm signing an order resetting the matter to, Mr. Higgins, what I want you to do is get a copy of it at the window outside the courtroom to your left, and, you take care of yourself, and if I don't see you, on the, September 26th, I'll be glad to strike the hearing, and hope you're doing well.
I'll be here if not.
Hey, you take care of yourself. Don't forget to get a copy of the order. Mr. Ellis, Sarah has not appeared. I think you're here for 9 o'clock? Oh, okay. Oh, that's, yeah, okay, yes, that was, well, that's it for right now, but if, we'll have private counsel. Any questions in the meantime, or? Back on record for the in custodies. The Squally Jail is now present by way of video. Mr. Aberco, good morning. Are you able to hear me? It looks like you.
I can hear you very well, Judge.
Thank you and good morning.
This is Mr. Norton.
Mr. Norton, good morning. For the record, Stephen Mark Norton.
Yes, sir.
I think what we're doing this morning is we're asking to reset all of his matters until after he believes he has a motion hearing in Puyallup Municipal Court with his attorney there. And perhaps it's one of those dispositive pretrial type motions. What's that?
That going to be able to be heard remotely?
Well, I spoke with his attorney in Puyallup a while back, and that seemed to be the plan, was that he was going to try to engineer some way possibly for Mr. Norton to appear at his hearing by video from the Nisqually jail.
Then we'll reset the matter to the next available date, September 12th, at 9 o'clock. Anything further in this matter?
I was hoping there was a possibility you could PR me, Your Honor, so I could handle those cases on my own.
Mr. Aberco?
Yeah, he mentioned that this morning, and he'd like to be released on his own recognizance. I know Your Honor set pretty high bail, so my experience has been typically, when bail is set fairly high, it's not likely the court will make a substantial change, but that's certainly his desire. Obviously, it's easier to try to.
My last paperwork said my bail was set at 25,000, not 250.
I think last time I looked up, Your Honor, was the bail 250? I don't remember what it was.
I believe so. I think, Mr. Norton, I'd like to, but you're on a deferred prosecution in a different county. You have a pending DUI up in Puyallup, and then a fourth DUI citation here. I've got to keep public safety in mind until I hear something by way of a treatment, bearing in mind you are on a deferred prosecution, and all that means I'm going to leave things. I don't think I have any alternative but to leave.
There is treatment in plan also, Your Honor, with the treehouse recovery and with the resources here. They told me I have to handle my Puyallup case before I can even sign ROIs for that treatment. And the paperwork I have also says that you set bail back down to 25,000 instead of 250. I don't know if that's true. It's what my paperwork says.
That's according to what we have, it's still 250.
Okay.
But Mr. Norton, I'm going to wish you the best of luck. We'll readdress the matter on the 12th. You take care.
Thank you.
Thank you.
Didn't think it. I don't know why I wouldn't.
Good morning, Your Honor. This is Mr. Lettle.
Mr. Little, good morning. For the record, Leighton Easton David Little. Is that your full
That's
name?
me.
Good morning, sir.
Good morning.
I'll turn to Mr. Aberco, your attorney, for the status of the matter.
I think the parties might have an agreement here to take care of it. I placed a stipulated order of continuance, conditions of which would be don't commit any criminal law violations for 6 months, no costs, the matter can be dismissed after 6 months. That way it's off Mr. Little's schedule and he doesn't really have to think about this anymore, and it kind of works out for the city as well. So we'd ask the court to accept it and inquire, please.
Mr. Little, I'm looking at a SOC, stipulated order of continuance in the O court system here. That's an agreement between yourself and the city, negotiated by your attorney, under the terms of which 6 months from now, this charge will be dismissed if you stay out of trouble. Is that your understanding?
Yes,
Now, in return for the agreement, you've given up your right to go to trial, have witnesses, appeal if you lose. If there's a violation of the agreement and the city proves that, we'll have a hearing based on the police reports and that alone, and that would almost certainly result in a conviction for knowing possession of a controlled substance. Maximum penalty would be 180 days in jail and or a $1,000 fine. You realize that?
yeah,
Mr. Little, are you still being held on another matter?
yeah, I got sentenced, I'll be out in October.
Great. I'm going to approve the agreement, 6 months. There's no fine. Just stay out of trouble. Case will be dismissed, okay?
Okay,
I'm gonna
thank
wish
you,
You take care of yourself, and I wish you the best of luck with your other matters as well.
thank you, you too.
Thank you, Judge.
Little. We're waiting for one more case from the jail. And until we resolve that or address that, we can't move forward. So I want to thank you for your patience. Jill, I note there's resets on the next block. So I want to address one or more of them at a time. Keeping in mind that usually just triggers an immediate response from the jail.
Yeah.
Okay. Morning, address the matter of Yelm versus Andrew Burke. Ms. Farina, good morning. We'll address that matter now.
Yes, thank you, Your Honor. I see my client in the courtroom.
Mr. Burke, come on up and have a seat if you would. Good morning, sir. For the record, full name, Andrew Carneal Burke.
Yes, Your Honor.
I'll turn to your attorney for the status of the matter.
Thank you, Your Honor. This is our first pretrial. As the court can see, Mr. Burke is serving our military and is scheduled to be deployed in October. So we've kind of fast-tracked getting all the conditions done. He's already completed his DUI victim impact panel. He's completed his evaluation and is scheduled to complete an 8-hour alcohol information school. So we anticipate hopefully resolving this at the next court date. I've reset it for September. I noted in Oak Court that I believe the 26th was the next available for the court, but I don't know if there's an earlier date.
Yes, we do have September 12th. If you prefer that, we can go there.
Yeah, why don't we do September 12th? I know that Mr. Burke is eager to get this resolved.
Mr. Burke, what we're going to do is reset the matter to September 12th. And once we do that, I'll sign an order to that effect. You can get a copy of that at the window outside the courtroom to your left. Stay in touch with your attorney and we'll readdress your matter, first court date in September. Any questions at all?
No, Your Honor.
Good luck to you. You take care of yourself.
You too, Your
And
Honor.
thank you for your service.
Your Honor, do you want me to update the date in Oak Court?
doing that as we speak.
Okay, thank you.
Sometimes O Courts is not as cooperative as we would want it to be. There we are. Order signed for September 12th.
Thank you, Your Honor. And I'm also covering a matter for Mr. Murphy from my office, the Michael Miller matter.
Michael Miller in the courtroom.
He's appearing through counsel, Your Honor, pursuant to 3.4. We've also, Mr. Miller or Mr. Murphy uploaded a motion to continue in Oak Court as well. This is the first pretrial.
The order continues the matter to October 24th. That's city have any objection? I'll sign the order resetting the matter to the 24th of October, and we'll be sending your client and yourself or Mr. Murphy a copy of today's order.
Thank you, Your Honor.
Ms. Farina, thank you. You take care.
Thank you.
We'll go back to the jail. Mr. Haverco, ready to address any remaining matters you have?
Yes, Your Honor, this is Mr. David Kane. Matter comes on for an arraignment this morning. I've had an opportunity to review the police officer's report with him, and I've had an opportunity to explain to him what an arraignment is. What he would like to do is waive formal arraignment, formal reading of the charges. I've gone over the charges with him, what the city would have to prove, maximums that could be imposed. He would like to just enter a plea today to, there's two counts. There's what's count of theft and a count of criminal trespass first degree. I anticipate he's going to enter a plea to the theft, and then the city, upon the court's acceptance of that plea, would move to dismiss count 2.
Good morning, sir. I'm appointing Mr. Haverco to represent you. Is your full name David Edward Kane?
Yeah.
Mr. Kane, do you disagree at all with anything Mr. Haverco just said?
Huh?
You indicated you're willing to resolve the matter at this time, waiving arraignment. Is that true? Is that correct?
I,
Can you hear?
yeah, yes.
Mr. Kane, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I would be free to impose that regardless of what's recommended by
I'm ready, yeah.
the attorney. If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing. You understand that?
Mm-hmm.
As part of the plea process, the city is moving to dismiss criminal trespass in the 1st degree. With that in mind, as to 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on August 25th, 2024, how do you plead guilty or not guilty?
Guilty,
You make that plea of your own free will.
of course.
Anybody make any threats or promises to make you plead guilty?
No.
Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph the plea form does satisfy the factual elements. Recommended sentence is 364 days in jail, all suspended on the condition you have law-abiding behavior. Do you have anything to add? That's it. Mr. Kane, anything you'd like to tell me?
No.
Mr. Kane, the only reason you're in jail instead of in the courtroom is because you won't go to court. You have 7 active warrants out for your arrest out of other courts. I don't know if you're going to be released at the end of today's hearing. Well, I'm going to release you. I'll follow the recommendation,
House 1C.
all suspended on the condition you have simply law-abiding behavior. My advice to you is just show up for court. That's the first step in the process. Keys to the jail are right there in your pocket. You just have to use them. Any questions at all?
No.
I'll take the head shake as a no. Mr. Haverco, anything further?
Thank you, Your Honor.
I'll sign the judgment and sentence. Mr. Kane, you'll be released on our hold, and good luck with your other matters.
Thank you, Judge.
Judgment and sentence signed this day. Back to the 9 o'clock calendar. Ms. Bowden has stepped out of the courtroom. Mr. Edsing, good morning. Well, we can address your matter now.
Good morning, Your Honor.
Good morning. I guess you're here on behalf of Mr. Barriga.
That's correct. I'm here for Mr. Barriga and Mr. Justin Mora, but we can take the Barriga matter first.
Is either Mr. Barriga or Mr. Mora in the courtroom?
Mr. Barriga is going to be appearing through counsel under 3.4 today, Your Honor. It's a defense motion to continue for further negotiation and investigation with the prosecutor's office. We're in the process of getting his treatment documents from the VA. It can prove difficult getting those documents from the VA sometimes, so that's kind of the reason for the delay. I've reviewed the waiver of speedy trial with Mr. Barriga, though.
The request is that we optimistically continue to October 10th. Hearing no objection from the city, we'll do just that.
Thank you, Your Honor.
Good luck with getting what you need.
Thank you.
Signing the order as we speak. We'll be sending you and your client a copy of the order. Also, on behalf of Mr. Mora.
And that's correct, Your Honor. Mr. Mora is also appearing through counsel under 3.4. I've had good communication with him and authority to waive speedy trial on his behalf. It's a defense motion to continue for further negotiation with the prosecutor's office.
I now have that. Reset to October 10th is the request. Mr. Ratfield, any objection? We'll reset the matter to October 10th. Send Mr. Mora and yourself a copy of today's orders.
Thank you, Your Honor.
Concludes the matter. Mr. Ansing, take care. Have a good day. We'll talk to you in October.
See you then. Thank you.
Morning, Mr. Goodman. Take your matter now.
Good morning, Your Honor. I'd like to call the Amanda Biles matter. And for the record, Jeremy Goodman, appearing under 3.4 on behalf of Ms. Biles with her approval, Your Honor. And I will let the court know, sorry, I did just get a chance to upload our defense motion to continue. I'm asking for a little bit later date for a couple of reasons, Your Honor. One, I'm going to be out a couple weeks in September. And the second reason is my client will be engaging in some significant treatment And I not only want the evaluation done, I want to get a couple compliance reports for her that I know will assist a lot with negotiations. So I'm asking for a little bit later date in October, on October 24th. I did discuss a waiver with her, and I did have it commence on that date to accommodate a little bit longer request in hopes that we can get close to resolution by then.
Any objection from the city? I'll need an order for that. It is. Oh, gosh. I went to the wrong docket. And we're gonna reset it to the 9 o'clock hour.
Okay, oh yeah, that works for me. Yeah, perfect. And that 10/24 day was still open, Your Honor, correct? I wasn't quite sure when I was looking at it. I didn't know if it was full. I thought it was open. Just want to make sure.
No problem.
Perfect.
4th, 9 a.m. Electronically signing the order as they speak. We'll be sending you and the client a copy.
Perfect. And I'll make sure to get her one too, and nothing further from defense.
Nothing further.
All right, thank you, Your Honor, and hope you have a good day.
In October. Have a good one.
Will do.
Still. Looking at that now, to September 26th. Council Reeves' appearance by sign the order, which will be sent to Mr. Rivera and council. Both matters, there's a civil infraction there as well. Both matters, I presume. Mr. Ergenbrack in the courtroom by any chance? Not here. Signing the order of dismissal as we speak. And record for Yelm versus Kurt Boyle. Ms. Bowden, I presume that matters. Ready to go? Good morning, sir. Is your full name Kurt, middle initial J Boyle?
Yes.
Mr. Boyle, good morning. Go ahead and have a seat. I'll defer to your attorney.
Thank you.
Perfect. Like the 90 days requested is probably not going to be needed. Mr. Boyle, I'm looking in O courts at a stipulated order of continuance. That's what it's called, a number of different things, but what it is a contract, an agreement between yourself and the city negotiated by your attorney, Ms. Bowden.
Okay.
Under the terms of this agreement, 24 months, not 25, 24 months from now, the charge will be reduced to a much less serious charge of negligent driving in the first degree if you comply with the terms of the agreement. The most important one to me is stay out of trouble, especially when it comes to alcohol-related events. In return for this agreement, to get the reduction, you've agreed to give up your rights to a jury trial, a trial of any kind. In other words, if there's a violation and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for DUI. I've said many times, and I'll repeat it here, the conviction for DUI is much more serious in terms of impact on your life than a lot of different felony convictions. Your attorneys put you in a position where the damage here can be minimized, but it's up to you to take advantage of the agreement. The reason why a DUI conviction is as bad as it is on your record in terms of jail time is the number of people we kill. You're already way ahead of the game. You're here, you're healthy, you're alive. Nobody got hurt. That's except your pocketbook and your time in court. I'm going to wish you the best of luck. I'll approve the agreement. That does require a $1,000 cost. I'm going to sign the agreement. You'll be able to get a copy of that at the window outside the courtroom and to your left.
Okay.
Signing the order dated today, 29th. September is just. Thank you. I'm going to wish you the best of luck, Mr. Boyle. That's if we don't learn from our mistakes, we all make them. You're bound to repeat it. And I had somebody here earlier today in custody on their working on their fourth. Don't go there. Don't go there. Learn from this. Stay healthy. Stay out of trouble and stay safe above and beyond all. I'm going to wish you the best of luck. You take care of yourself, okay? Ms. Bowden, thank you. You take care. Have a good one. Signing. Now back on record.
Thank you. So, if we could call the matter of Jeffrey Baker, it's item number 1 on the 10 o'clock calendar. It's for minor in possession and or consumption. City's gonna make a motion to dismiss. He had done a deferred prosecution on this case, and then more importantly, on his DUI matter. And my understanding, he is in treatment. I've spoken with him. He's in treatment. What happened was DOL kicked the deferred prosecution back because we tried to put both on the deferred prosecution and they were more than 7 days apart. So just as a matter of
Oh, I remember that,
yeah,
yes.
so just as a matter of housekeeping, city's gonna move to dismiss this charge, so we can just continue.
So you can proceed with the DP, yes. On presentation, I'll sign the order. And that's good to know. That's, I did not realize that. But
Yeah. I vaguely remember that. You can do 2 different cases on a deferred. You have to,
within 7 days,
yeah, it's buried somewhere in Pennsylvania. That,
I was not aware of that. I evidently did not dig deep enough into 1005.
right,
And why?
yeah, and he's. in
Why not 3
treatment.
days?
I've
Why not
spoken
12
to him.
days?
Yeah, he-
Why not 30 days?
Yeah, he started out in inpatient treatment, so I mean, he actually is.
Yeah,
You know, he's in treatment, so.
so why not? Yeah.
Yeah.
Ours is not to reason why.
When I get my computer fired up, I think we can take up Mr. Andrew Lewis.
Stating the order of dismissal as we speak.
Andrew, why don't you come on up? Mr. Woods has just signed, the stipulated order of continuance.
I'm looking at it on the.
Yeah.
Good morning, sir. Your full name, Andrew, middle initial W Woods. And that's, Mr. Havico, that's, anything you wish to say? Or?
We'll just review here.
It looks like the conditions are pretty
Yeah.
simple. Stay out
Yeah,
of
just
trouble.
the standard stuff, yeah, and part of the rationale of entering into this here is he's currently, was accepted into drug court in Superior Court.
Oh,
And
wonderful.
so he was trying to avoid a concurrent conviction. So kind of the rationale is let him do his treatment and
Absolutely.
try to stay law abiding, you know, and have an opportunity. If he succeeds over there, he'll succeed here. So.
Mr. Woods, all I can do is wish you the best of luck with it. I'm looking at this SOC. It's an agreement under the terms of which this charge will be dismissed. You have a couple of things happen. If you just simply stay out of trouble. That's really the most important thing. Deal with the drug issue. As far as I'm concerned, everybody can live their own life, but possession of certain substances is against the law, and I would like to see you save your own life. The statistics of the number of people that are dying from fentanyl, et cetera, are kind of scary. That's good to hear. The county program, I'm very familiar with that. That's an excellent one. I've had a number of clients go through that and succeed. And yes, it's all that, that's what this is all about, is saving your life. In return for the agreement, you've given up the right to go to trial. There's a violation. The city proves that. We'll have a hearing based on the police reports. You know where that would go. Maximum of 180 and 1,000. But the sentence you're trying to avoid is a life sentence of no more life. Cheerfully sign the order. I'm going to wish you the best of luck in drug court. There's no smooth path to recovery. All I can do is, if you happen to fall down, just get up. Just get up. Keep dealing with it. I want you to succeed in the drug court. Who's running that now? It was
I don't know.
Rick's trophy, but yeah, they have different.
Pierce County line.
Oh, okay. Good luck with that. Mr. Woods, I'm signing the order as we speak. I want you to get a copy of that at the window outside the courtroom and to your left. Have any questions at all? Read it over carefully and give Mr. Africo a call. In the meantime, good luck. Stay well. Stay safe.
You don't have to come back.
Mr. Woods, the financial part of it, the 250, that's the least of my concerns. If that becomes an issue making the payments, just let Mr. Abaco know. We'll readdress that. We can deal with. You take care of yourself.
This is item number 9 on the 10 o'clock. This is Mr. Mohammed Camille proposing that proposing the court accept a stipulated order of continuance and conditions, 12 months law-abiding behavior, no criminal law violations, A250, at the end of which time the city would move to dismiss.
Good morning, sir. Full name Mohammed Shriel Kabil. I'm looking at a SOC, stipulated order of continuance in the old court system here. This is a contract under the terms of which, if you do what you're agreeing to do here, this charge kind of goes away. That's a matter of I think 12 months. Most important thing is stay out of trouble. The less important thing is a $250 probation monitoring fee, which is not the most important thing to me. If you have trouble making the payments, let me know. But in return for the agreement, you've given up the right to go to trial. If you violate the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction. We don't want to go there. That's it. What I want you to do is get a copy of today's order at the window, and the thing about with this offense, it can lead to all sorts of unpleasant things. I'm going to wish you the best of luck. You take care of yourself, Mr. Camille, and again, get a copy of the order, read it over carefully. Mr. Haverco's there if you need his advice. Mr. Averco will call the matter of Yelm versus the Wren, Michael Burnham. Mr. Burnham, is that your full name?
Yes, sir.
Hey, thank you. I'll defer to you, Mr. Averco, for the status of the matter.
Thank you, Your Honor. Let me just review here. So, I think the parties have reached an agreement. One second. Go into edit mode. Need to fill in that one. Yeah, so the matter comes for a pretrial hearing on this matter. I think the parties have reached an agreement, that being a 2-year stipulated order of continuance. During which time it's the usual kind of DUI related conditions. What would be the fine on a DUI, which is $990.50.
Don't forget the 50 cents.
And 50 cents. And at the end of which time the case would be amended to negligent driving in the first degree. And again, you know, just essentially no alcohol related, you know, violations. I've reviewed with him all of the various things. He has to do alcohol drug evaluation. ADIS is waived, a treatment is recommended. I just put that in there. DUI victim impact panel. He has, in my discussions with him, he has actually gone through some significant inpatient treatment with the VA, right? Yeah, with the VA. He's got from Bayview Recovery, he brought with him today, a completion of treatment certificate. It was a completion of level 2.5, not sure what that is, but partial hospitalization program. This is on behalf of the Bayview Recovery Treatment Team on 10/10/2023. Congratulations on your achievements in completing your treatment successfully. So my prediction is that just because this is from October of 23, so it's not yesterday, the court would, you know, it would make sense to get an updated evaluation, but I anticipate.
Would be required.
Right, but I anticipate the result of that evaluation probably won't be more treatment.
That would be my guess as well.
Be my guess.
Unless there's some intervening new
Yeah.
issue,
So he's,
I would so assume.
yeah, he's maintained a certain. I can't hear him.
Okay, I'll try to speak up.
Thank you.
Go ahead.
Yeah, he's gone through some pretty comprehensive treatment already. So I assume what's gonna happen is when he gets an updated evaluation based on his length of time of sobriety and his past treatment, they're probably not gonna recommend anything other than probably alcohol drug information school perhaps. And just, you know, to maintain sobriety and obviously as part of the original DUI charge, normally the court would impose or would have to impose the victim impact panel, which makes sense to do that regardless. But I don't anticipate he's probably going to wind up actually doing treatment. So he seems to have been sober now for quite some time and to understand that he had a real problem. And so that's where we are. We're here so late in the game because this was a blood test case and the results came back much, much later. So it's
The lab runs its own schedule.
Right.
City, have anything to add? Mr. Burnham, I'm looking at a SOC, a contract between yourself and the city negotiated by your attorney. Have you gone over the matter with your attorney, with Mr. Averco? And if you had any questions about what you were getting yourself into, was your question answered?
Sure.
Now, we're resetting the matter out 2 years. And if during those 2 years you do what you're supposed to do, charge will be amended to a much less serious charge of neg 1, negligent driving in the first degree. The most important thing is no drinking and driving, no violation of the criminal rules, stay out of trouble. Less important is the $990.50 that you've agreed to pay over time, $50 a month. If there's a problem making the payments, let us know. We can deal with that. Now, if you,
I'm in the process of renewing my driver's license. because it's gonna be suspended on the 29th of this month. And I've already gone to DOL, I've been up there, got an appointment on the 3rd. They couldn't get me on the 29th.
Labor Day.
So I'm just gonna have to go without driving the 29th and the 3rd, but I have to expect it. I don't mind.
And there's nothing I can do about that. The Department of Licensing, they have their own way of doing things, and
But I just want to point out that I am being actively involved in
that's good to hear.
recovering my, driver's license.
You've had quite a little run here. I'm hoping that things are on the right track. They certainly seem to be. But I'm going to approve the agreement. I want you to get a copy of that at the window, or we could certainly at the police window. That's outside the courtroom and to your right.
Yes, sir.
Look it over carefully, and if you have any questions, give Mr. Abaco a call. Okay, hold on. Burnham, there's also a review of the earlier matters, the protection order violations one. I'll turn to the city. Has the city taken any action at all on those at that time? Now, those are still live, active cases. There's the possibility of suspended jail time. I want you to stay out of jail. You've had enough of that, I think. And the keys are right there in your pocket. Whether you go back to jail or not, there's up to one person, and I'm looking at him right now. I'm going to wish you the best of luck. You take care of yourself. Still fine. The continuous is up, but the costs remain unpaid. Yeah.
You were on, you were on a kind of probation agreement on the no contact order.
Mhm.
You owe a little bit of money and you get that paid.
This is different. The cases here are different than the case in the Superior Court. Yes, I'm aware of what happened up there,
Okay,
but that has nothing to do with this. This is separate. This is something different.
well, I know nothing about what happened here. As far as any payments or anything.
Well, then can we, extend the time a little
I
bit?
mean,
on
if I
that?
have to
And then he
pay
can
a
talk,
fine, I'll pay a fine.
and he can talk to the clerk and get some additional information. So before you leave today, you still owe money on this older case. Talk to the clerk, she'll tell you what you owe. If you can pay it today, great. If not, just take care of that. So you'll get the benefit of that deal.
I will take care of it.
The city has agreed to extend your agreement with them for 6 months.
Okay, sir.
So that'll give you a little time to get your feet on the ground, get these things taken care of, okay?
Yes, sir.
Any questions?
Negative, sir.
Good luck to you.
So before you go, wait out
No,
here.
to the right. No, Mr. Abaco. This way.
This one?
Yes.
Okay.
I think they're good.
So.
At the police window.
So get your paperwork. from the police department. All right.
Mr. Burnham, good luck.
So get your paperwork.
Try to stop shouting.
And just for the court's information, Mr. Baker did show up. Mr. Baker, you're free to leave because we already called your case today. The city agreed to dismiss it. So the MIP minor possession, that's just dismissed. So you're still on your, so you're free to go. You're still on your deferred prosecution for your, you know, the DUI situation. So just keep doing what you're doing. Keep staying out of trouble. All right.
Mr. Baker, how are you doing? Doing well, doing well. Nobody shot at me recently, so that's, you look healthy, you look happy. Yeah, we dismissed your other case to, apparently the Department of Licensing has a rule that, we weren't aware of, but that's straightened out, case dismissed. But I wanted to wish you the best of luck with what you're doing. You take care of yourself.
Yeah.
Matters ready? If not, we'll go into recess. Good afternoon, sir. Or good morning, sorry.
This is, tell me. Oh, okay. So Your Honor, this is, Mr. Ronald Sanchez. It's item number 2 on the 9:45 a.m. Calendar. Comes on after a previous FTA. So, I would just ask the court to reset the matter so that I have some time to meet with Mr. Sanchez.
Okay. How far out do you want to go?
Ordinary court.
Right, September. Mr. Sanchez, yeah, it's important to appear in court. If for some reason you can't get to court, just let us know. Let us know and we can reset it. The important thing is stay in touch. Now, we're going to give you a notice to reappear September 12th. You can get a copy of that notice at the window outside the courtroom and to your left. I want to thank you for appearing. And we'll get the matter back on track. You take care of yourself. And you as well.
So this is Tyler Sorensen. He has three,
Sorensen, good morning.
yeah, 3 matters on the 10 o'clock.
And we're having an O-Court issue, can't seem to get back to the dashboard and
Oh,
given my cyber incompetence, I need assistance to deal with this, Mr. Sorensen. Back up and running.
okay. Oh, I apologize. Sorry about that. Sorry about that.
Good morning, Mr. Sorensen. Tyler James Sorensen is your full name. I'll defer to your attorney for the status of the matter.
Thank you, Your Honor. Yeah, he has 3 matters on this morning on the 10 o'clock calendar. A show cause, compliance case and a couple pre-trials. He's going to be entering a plea to the obstruction charge. Upon the court's acceptance of that plea, city will move to dismiss the suspended driving 3rd-degree charge. And I don't believe the city is taking any action on the compliance matter.
Mr. Radfield, that's correct. Mr. Sorensen, I'm looking at a statement of defendant on plea of guilty to 1 count of obstructing a law enforcement officer in the performance of his duty. That's what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. If I accept the plea, I'd be free to impose that up to the maximum if I saw fit, regardless of what's recommended. Also, if I accept the plea, there isn't any trial, no appeal. You've given that up, and we'll simply have a sentencing. Understood? That in mind, as to 1 count of obstructing a law enforcement officer in the performance of his duty alleged to have occurred within the city of Yelm on July 12th, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises for you to make it plead guilty? We'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. As a part of the process, I will dismiss the DWS 3rd charge as well. Mr. Havico, with regard to sentencing,
It's all recommendations, all suspended jail time, no criminal law violations for 12 months, pay a $250 court fee. He may want to make payments, and then at the end, which time the matter can be closed.
City, have anything further? Mr. Sorensen, you have a right to tell me whatever you want. You don't have to say anything, but if you want me to know anything, now's the time. Okay. I'm going to follow the recommendation, 364 days in jail, suspended on the condition of law-abiding behavior, and $250 costs. You can pay that at $25 a month. Taking no action with regard to the diversion that you're on, simply wish you to, keep up with the obligations there, and most importantly, stay out of trouble. Signing the judgment and sentence in open court at this time. Mr. Sorensen, what I want you to do is get a copy of the today's pleadings and the judgment and sentence at the window. Look it over carefully, and if you have any questions, give us a call. Do you know what you need to is your license? Do you know what you need to do to reinstate that? I check with the Department of Licensing. We live in a world where you pretty much have to be able to drive. So I sort of make that a project. Can't order you to do anything, but make it a project, okay? Any questions? Good luck to you. Take care of yourself. Says,
This is Mr. McCullough. Comes before the court for a pretrial hearing on a, it's item number 10 on the 10 o'clock calendar. Matter comes before the court for a pretrial hearing on a hit and run intended charge. Parties have reached an agreement, that being a 12-month stipulated order of continuance. The matter to be continued for 12 months on the condition that he have no new criminal law violations, pay a $250 court fee, at the end of which time then the city would move to amend the charge to negligent driving in the second degree, a civil infraction.
full name, Ethan, middle initial P, McCullough. Mr. McCullough, do you disagree at all with anything Mr. Havercoat just said? You've got an agreement here under the terms of which a pretty serious criminal offense can get reduced to a civil infraction. What you need to do is, over the next 12 months, just stay out of trouble. If you happen to get in an accident, make sure all the information necessary is exchanged. But mostly, just stay out of trouble. Now, in return for the agreement to get this charge reduced, you've given up your rights to a trial. You violate the agreement. City proves that by a preponderance of the evidence. We'll have a hearing based on the police reports, and that would almost certainly result in a conviction that bears jail time up to 1 day short of a year in jail. I'm going to wish you the best of luck. You've got a good agreement here. You take care of yourself, and I'll look forward to a year from now knocking the matter down to a civil infraction. Any questions at all? Good luck. Get a copy of the SOC at the window outside the courtroom to your left. Look it over carefully. Any questions? Give us a call, okay? Take care of yourself.
Yeah, pretty good. This is Mr. Hunt.
Your full name, David Hunt? Thank you, Mr. Hunt. I'll turn to you, your attorney, for the status of the matter.
One second. He now just signed a statement of intent on plea of guilty. I anticipate he's going to enter a straight plea to the charge. The recommendation is just all suspended time. All time suspended for 12 months on the condition. Don't commit any new criminal law violations. Pay a $250 court fee. You can make payments, at the end of which time the matter can be closed.
Sir, do you disagree with anything at all Mr. Havercoat just said? I'm looking at a statement of defendant on plea of guilty to one count of violating a protection order entered lawfully. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I've heard the recommendation, but I would be free to impose up to the maximum if that's what I saw fit to do. You realize that? Yeah. Okay. I accept the plea, no trial, no appeal, simply at sentencing. With that in mind, I ask you as to one count of violating the terms and conditions of a protection order within the city of Yelm on July 3rd, 2024. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. City, have anything to add by way of sentencing? Mr. Havercoat, anything further?
Nothing to add, Your Honor. Just ask the court to follow the recommendation.
Mr. Hunt, you have a right to tell me anything you want. You think I should know, you don't have to say anything. But if you want me to know anything, now is the time. I'm gonna follow the recommendation, and remind you that, yeah, in law now, these protection orders are, they're a serious matter. And even if the contact is totally voluntary and consensual, it's still a violation, whether it is or not. All jail, excuse me, all jail time suspended, on the condition you have law-abiding behavior. Stay out of trouble. $250 in costs. You can pay that, 25 a month. And if you have problems making the payments, let us know, okay? Mr. Rudd, good luck to you. Take care of yourself.
I've got 3 folks I need to speak with, and I haven't had an opportunity.
We'll go off record, until you've had a chance to, On record, we're missing a prosecutor, but he will be with us shortly. Mr. Aberco, go ahead.
Oh, thank you, Your Honor. This is Jessica DeGunia. She's item number is 4, 5, and 6 on the 10 o'clock calendar. I think the parties have reached an agreement. She's entering into a stipulated order of continuance. The suspended driving third degree case will be amended today to no valid operator's license with ID. The other two matters, the controlled substance violation and the theft, will be on a 12-month stipulated order of continuance, continued for 12 months on the condition that she not have any new criminal law violations to pay and pay a $250 court fee. And we weren't looking to impose a separate fee on the suspended case. That's just going to be an infraction.
That would go in today as a committed.
Yeah,
What was it?
correct. Yeah.
Good morning, ma'am. Full name Jessica, middle initial M. Begunia. If I mispronounce that, I apologize. Apparently, the city is amending a DWS third to a civil infraction of NVOL second degree. If you admit that, we'll simply have that be a committed infraction. I'm also looking at an SOC stipulated order of continuance on the other charges, controlled substance, knowing possession, and theft in the third degree. An SOC, I assume you've gone over that with Mr. Haverco. It's an agreement between yourself and the city, negotiated by your attorney, under the terms of which these matters can go away. They can be dismissed if you comply with the conditions set forth in the agreement. The most important one is stay out of trouble. No criminal law violations at all. If you violate the agreement, city proves that, you've given up your right to go to trial, we'll have a hearing based on the police reports, and that would lead to the possibility of significant jail time and convictions for some serious offenses. I'm hoping that 12 months from now, we can simply dismiss the charges and close the case. You can pay the $250 costs at $25 a month. First payment would be due September 29th. You've got a chance to walk away from these charges with dismissal. It's up to you whether you do that or not. I'm going to wish you the best of luck. What I want you to do is go to the window outside the courtroom to your left. You'll get a copy of this agreement. I want you to read it over carefully. And if you have any questions about what it means, what you're obligated yourself to do, let Mr. Haverco know. Okay? Mr. Gunia, good luck to you. You take care of yourself. That's it.
Mr. Bushel?
Back to the dashboard, Mr. Haverco.
Yep. Go inside. This is Cody Peschel. It's item number 11 on the 10 o'clock calendar. Parties are proposing a stipulated order of continuance. Continued for 12 months on the condition of no criminal law violations. A $250 court fee, at the end of which time, if he abides by the agreement, the city would then move to dismiss.
Full name Cody Stakeen Peschel. If there's a way to mispronounce a name, I'm going to do it. That's it. I'm looking at the SOC, the contract. This is a little repetitious now. It's an agreement whereby you can simply get this matter closed, but you got to stay out of trouble to do it. That's the most important thing. And again, if you violate the agreement and the city proves that, you've given up your rights to go to trial. We'll have a hearing based on the police reports, and that third is a gross misdemeanor. The max is 364 days. You don't want to even go there. $250 that can be paid at the $25 a month. I'm going to wish you the best of luck. You take care of yourself. And again, I want you to go to the window, get a copy of the agreement. It's kind of lengthy. Look it over carefully. And if you have any questions, Mr. Haverco is available to answer any questions you might have. I'm going to wish you the best of luck. Thank you for your patience. You take care of yourself. Any questions? Good luck, sir.
Moving to the 11 o'clock calendar, Ms. Croft, Michelle Croft. Parties have reached an agreement. Stipulated order of continuance, matter to be continued for 24 months on the condition that she remain law abiding, submit to an alcohol drug evaluation, comply with any recommended treatment, alcohol drug information school, although that is to be waived if treatment is recommended. Victim impact panel. If she complies with that agreement, at the end of the agreement period, the city would move to amend the charge to negligent driving in the first degree. She has had an evaluation. It may be sitting in my email that I haven't seen, and that's okay. I just told her that. You know, the court, as part of the agreement, will give her a period of time in which to submit the evaluation to the court. And just the main thing is just get your hands on a copy of the evaluation yourself. Just make sure it's and so the judge can review.
Good morning, ma'am. For the record, your name is Michelle Leanne Croft. Well, I'm looking at the SOC stipulated order of continuance. It's called a lot of different things. It's a contract. It's an agreement under the terms of which 24 months from now, this charge, DUI, can get reduced to neg 1, negligent driving in the first degree. That's a much less serious offense than GUI. In return for the agreement to get the reduction, you're agreeing to stay out of trouble, get a drug and alcohol evaluation, and comply with any recommendation. You're also giving up the rights you have to go to trial, have witnesses, appeal if you lose. In other words, if the city proves that you violated the agreement in any way, we'll have a hearing based on the police reports, and that would most certainly result in a conviction for a pretty serious offense. I'll say it again, DUI conviction is worse in terms of impact on your life than a lot of felony convictions. The important thing is you're here, you're not hurt, you didn't hurt anybody, but that's why this is as serious as it is. Signing the agreement, what I want you to do again is make sure you know exactly what you're getting into. Get a copy of the agreement at the window. Read it over carefully, and if you have any question at all, make sure Mr. Averco learns that. As far as the fine or assessment is excuse me, concerned, that's the least of my concern. If you have difficulty making the payments, let us know. We can deal with that. Any questions at all? Good luck to you.
Next matter would be Gloria Goldman.
Good luck, Ms. Croft.
Should probably be. I'm gonna input a defense motion to continue. The city's ultimate intention on this case ultimately is to dismiss once it's been verified that the back B&O tax has been paid. But apparently the check hasn't cleared based on maybe when the check was made. So the city just wants to reset it for the purpose of just verifying the payment, and then the intention, like I say, once the city determines that it is actually paid, then.
Morning, ma'am. Your full name, Gloria J. Goldman. Right?
I'm just working on
Looking
it.
for a reset here to out
Yeah.
to how much time?
I would say, I don't even know if we need a waiver. We could probably just reset it 2 weeks for something like this.
If that's all you want,
Yeah.
we can certainly send it
Do
over
I still need to
the
put
twelfth.
it, do I still need to put in a motion though for the? I can't.
Just do a notice.
Oh. Okay.
Goldman, we're gonna give you a notice of hearing, for 12th of this next month.
Oh,
Yeah, this is one of those financial deals. It sounds like it's just a matter of getting things worked out.
So I just need to have you sign the notice to show up. Okay. It's giving me an error found. Let me save it. Okay. I was trying to close out the notice of hearing. Did it save the signature? She didn't. Let me have her sign one more. Sign one more. Okay.
There we go.
Okay.
Goldman, if you get the copy of the notice at the counter outside the courtroom to your left, we'll see you back here in a couple of weeks. You take care of yourself.
Okay, take care. No, you don't.
Hey, thank you, ma'am.
Mr. Herzog? So this is John Edward Herzog.
Full name, John Edward Herzog?
Yes.
Hey, good morning, sir.
Couple matters come on before the court, both pretrial hearings, two cases. Total of 4 charges between the two. He intends on the case ending in 449, the malicious mischief, criminal trespass, theft case. He intends on entering Alfred pleas to counts 2 and 3, the criminal trespass second degree charge and the theft charge. Upon the court's acceptance of those pleas, city would move to dismiss in that case. Count 1, the malicious mischief third degree case. They would also move then to dismiss his other case, the malicious mischief case, which is item number 7. And I have reviewed the police reports with him, and I've gone over the evidence. He does agree that with his understanding of that evidence available to the city, if that were presented to a finder of fact along with any evidence that he may present, there's a high likelihood that a finding of guilt would be entered. Because of that, he wants to take advantage of the plea offer and do the plea today. The other reason, Judge, he's entering an Alfred plea is it's kind of a memory issue. He doesn't necessarily really have full recall. Probably having to do with some maybe substances perhaps. So he just doesn't recall those. But he
No doubt.
understands, I believe, what an Alfred plea is. And I think we're ready to proceed. Ask you to inquire.
Hey, Mr. Herzog, do you disagree at all with anything that Mr. Havercode just said? That's it. I'm looking at a statement of defendant on plea of guilty to 2 things. 1, criminal trespass second degree. That's a simple misdemeanor. The maximum on conviction would be 90 days in jail and or a $1,000 fine. You're also pleading guilty to one count of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty for that would be 364 days in jail and or a $5,000 fine. Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, and that could be up to the maximum if I saw fit to do so, regardless of the recommendation. Do you realize that? With that in mind, as to one count of criminal trespass 2nd degree and one count of theft in the 3rd degree, alleged to have occurred within the city of Yelm on April 13th, 2024. Excuse me, 2022. How do you plead guilty or not guilty? You make those pleas of your own free will. Anybody make any threats or promises to you to make you plead guilty? Now, as Mr. Haverhill indicated, these are what they call Alfred pleas. You're not pleading guilty, but you have reviewed the police reports and realized that if you did go to trial on it, things could go badly and you want to take advantage of the plea offer. Is that correct? That's it. I do find there is sufficient factual basis based on the probable cause statements in the file. Mr. Herzog, anything you'd like to tell me? Mr. Haverhill, anything further?
The only thing I would add is, his current status is, my understanding is more or less homeless at this point. As part of the city's standard recommendation, they're asking for a $250 court fee based on its indigency. I would ask the court to waive any financial obligations.
No employment, no.
He's not working
Income.
and doesn't have any visible means of support at this point, none that I know of.
City have anything further? That's it. Mr. Herzog, that's sometimes happens that we don't remember what happened if our judgment or memory is clouded by certain things that some we have control over and some things we don't. I am going to follow the recommendation here, 364 days, all suspended on the theft 3rd, 90 days all suspended on the criminal trespass 2nd degree. On the condition you simply have law-abiding behavior. I don't see any point in imposing any fine on you that you don't have any apparent ability to pay. I just want you to, I just like to see you survive and survive and try to stay, substance free. So that'd be a good idea. I want you to go to the window, get a copy of today's judgment and sentence, which I'm electronically signing now, and look it over carefully and give Mr. Haverhill a call if you have any questions. Mr. Herzog, I'm wishing you the best of luck. You take care of yourself. Thank you, Mr. Herzog.
We could call the matter of Romeo Rodriguez, item number 10.
I'm still doing the paperwork. Hold on. Now, I didn't catch your name, Mr. Haverhill. This is?
Oh, this is Romeo, first name, last name.
Rodriguez?
Rodriguez, he's item number 10. Comes for a pretrial hearing on a theft charge. I believe the city has a motion on this case.
Full name Romeo Elijah Rodriguez.
Right, sir.
I hear no objection. On presentation, I'll sign an order of dismissal. Mr. Rodriguez, that concludes the matter. If you need a copy of the order of dismissal, it'll appear here in a moment. You can get a copy of that at the window if you need one. You can get it now or in the future at any time. Any questions at all? Good luck to you. What are you doing?
This
dismissal?
is,
Oh. Usually a failing on my part.
sorry on this.
Good morning, man.
So this is Leah Evans. Matter comes before the court today for a pretrial hearing on use of paraphernalia, drug paraphernalia, and a controlled substance knowingly possessed. Parties have a proposed agreement, that being a stipulated order of continuance, the matter to be continued for 12 months on the condition that she not commit new criminal law violations, pay a $250 court fee, at the end of which time then the city would move to dismiss.
Almost there. Full name Leah May Evans. Ms. Evans, in a moment, I'll be able to look at an SOC, stipulated order of continuance. 12 months down the road, we look forward to dismissing this charge. But that's conditional. You've got to abide by the terms of the agreement. Stay out of trouble. That's the most important thing here. The other thing is that there's a $250 cost associated with the agreement. Now, in return for the agreement to have the charges dismissed, you're giving up the rights contained in paragraph contained in any plea agreement. There's going to be no trial, no appeal. You violate, that's proven. There'll be a hearing based on the police reports. That'll conclude the matter and result in the possibility of conviction and jail time. You've got a little bit on the line here. Given the nature of the charged offenses, I'm going to urge you to do whatever is necessary to make sure that that doesn't become a problem in life. Don't want to go there, okay? Ms. Evans, it's taken me a moment to get back to the right section in the computer. I am now signing off on the agreement. It's between yourself and the city. That's I'm going to hope you fully comply with it, and then we can simply dismiss the charges 12 months from now. Okay. Any questions at all? I'm going to wish you good luck. You take care of yourself. Back on record, Mr. Everco?
Yeah, just give me one moment here, just take me a second here.
I have to do, ma'am, your name, please. Eternity Bach.
So Ms. Bach has just signed a statement of defendant on plea of guilty. I anticipate she's going to enter a straight plea to the amended charge of criminal trespass in the second degree. It's going to be a straight plea. The city's going to recommend 90 days in jail, all suspended for 12 months on the condition of no criminal law violations. Because of her homeless status, the city is not going to recommend any financial obligations in this case.
Good morning, ma'am. Do you disagree with anything that Mr. Everco just said? Is your full name Eternity Rose Ellen Bach? That's it. I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, amended down from first degree. Second degree is a simple misdemeanor. The maximum penalty for that would be 90 days in jail and or a $1,000 fine. I would be free to impose that regardless of what's recommended if I saw it as being appropriate to do so. You realize that. And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. With that in mind, as to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on July 1st, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Heard the recommendation. Mr. Havergo, anything to add?
Nothing to add, just ask the court to follow it.
Mr. Havergo, anything to add to the? Ms. Bach, you have a right to tell me anything you wish. You don't have to say anything, but if you want me to know anything about your circumstances, now's the time. Okay. I'll follow the recommendation. 90 days, all suspended on the condition you have law-abiding behavior. That's the only condition. Stay out of trouble, period. That includes don't go to places where you're not supposed to be. Not going to impose any fine given your financial situation. I see no point in doing that. That concludes the matter. I will sign off on the judgment and sentence. I'm going through that on the computer right now. I want you to get a copy of today's paperwork at the window outside the courtroom to your left. Look it over carefully, and if you have any questions at all about what it means, give Mr. Haverco a call, okay? I'm going to wish you the best of luck. You take care of yourself.
Okay, free will.
Yes, sir. That you would have to take up with the police department. Why they did that, I don't know. I would ask. I would ask.
Let's do the signature again. Sorry. So this is Heidi Molnar,
Good afternoon.
and matter comes before the court for pretrial hearing on a DOI. Parties have reached an agreement, that being a 24-month stipulated order of continuance. The matter be continued for 24 months on the condition that she abide by all of the stated conditions in the agreement, all the DOI related conditions, $990.50 fine, alcohol drug evaluation, comply with any recommended treatment. ADIS waived if treatment is recommended. She has a prior DUI from 1997. The charge then to be amended at the end of 2 years to that of reckless driving. I advised her, reckless driving, yeah, I advised her it's what we call in the defense biz, a slow reckless. And you know, an attempt was made to try to persuade the city to do a slow neg, but it just, you know, the city's position was because of the prior DUI from 97, they just weren't.
Sometime back, but
Yeah.
still there.
Yeah. But, you know, it's still better than, you know, driving under the influence charge,
Oh, yes.
you know, so.
Good afternoon, ma'am. Full name Heidi Roberta Mulder. Ms. Mulder, I'm looking at a SOC, a contract between yourself and the city negotiated by your attorney. 2 years down the road, we're going to amend the matter and have it go in as a conviction for reckless driving. But that depends on your compliance with the conditions. The most important one here is never again, never again. Sometimes, yes, we have to be hit over the head a couple of times to, you know, to get it. And I'm hoping that this is going to be the absolute last time. The risks of getting behind the wheel of a car when you're impaired are borne out by the fact that we kill thousands nationally every year. If the city proves you have violated the conditions, we'll have a hearing based on the police reports alone, and that'll lead to, more likely than not, a conviction for DUI, which is horrible in terms of impact on your life and your driving. The less important matter is the probation fee of $990.50. That's significant, but that you need to pay that at the rate of $45 a month is set forth in the agreement. Any questions at all? Yeah, get the drug and alcohol evaluation, get that within 90 days and start complying with any recommendations they make. Hey, if there's an issue here, a problem here, what we want to do is make sure that that's taken care of. That problem is addressed and it doesn't happen again. I don't want to read your name in the paper or hear your name on the news at all. That's happened to me way too many times. Live a good life, take care of yourself, and be safe. Smolder, I want you to get a copy of today's agreement at the window outside the courtroom and to your left. Look it over carefully and give Mr. Everco a call if you have any questions, okay? Good luck to you. And I guess that brings us to the no-shows.
Yeah.
Unfortunately, Mr. Elisara, I spoke to him yesterday. You need a moment?
Oh, I was just returning a call to Mr. Wilson, who has called me a couple of times this morning. He didn't leave a message as to why he's not here, but he did call.
That's
so-
significant. That's
Yeah.
significant.
So I assume he was wanting to tell me why he's not here.
Mr. Elisara yesterday assured me, promised that he would be here this morning. And it's just a financial thing. Oh, 500 cash or bond.
And who is this on?
Elisara, page 1, docket number 2. That was one of the reviews. picked up on a warrant, not for the first time or the
Oh.
second time, but it's an SOC.
I see. Oh, gotcha.
And we'll see how Mr. Higgins does with his new treatment agency. Sometimes you wonder about that. The in custodies, they all appeared.
Yeah, it's amazing how that happens.
9 o'clock, the problem what we have is number one, Tyler Dean Anderson. That's the one where both the attorney and the defendant did not appear. June 6th, reset out of courtesy to counsel for July 18th. Did not appear July 18th. Rescheduled today for as courtesy to, well, that's always kind of problematic as to what to do with these things. But so ordered, the warrant that I'm gonna ask Madam Clerk to reach out to and if you can get, if you can find some reason why the matter needs to be reset, fine. If not, I'll sign the order or the warrant before we leave today. Well, 500 cash or bond, at least it's a little deal. The next no-show I have goes to the Sean Ray Bauman. Just leave the warrant in effect. Going to the pre-trials. I overlooked that. Tina Dawson. That's I did sign the order to withdraw submitted by Ms. Farina. There's a docket note that the defendant lives out of state. I'm inclined to issue a warrant since the attorney's withdrawn, apparently lost touch with the client. So ordered 1,000 cash or bond. Yeah, missed that one, sorry.
On the 10 o'clock, Mr. Dudley, that was a long previous FTA. So I haven't talked, I haven't talked to him for a very long time, so I have no information.
Case is over 4 years old. It's
Yeah.
City moved for a warrant, 1,000 cash or bond. So ordered.
And on Robert Wilson, he did call, like, I think 2 or 3 times. He did leave a voicemail. He unfortunately didn't tell me why he's not in court, but he did say it was Robert Wilson and was wanting me to call him. So I just tried to call him a couple of times and I'm getting his voicemail. I was hoping I'd get him on the phone. So I do have a number for him, but I don't have information from him as to why he's not here. I could ask the court to consider maybe just noting the failure to appear for speedy trial purposes and reset with notice.
So inclined. That's note of non-appearance, speedy trial purposes, reset to the 12th with notice. And that's how about Chris Kenny is the next one? Any word from him at all?
On which one?
Docket number 8, page 12.
Oh.
Christopher Freedom Kenny.
Oh. Let me see. I have spoken with him about his case around I'd have to look up in my notes, but it wasn't last week. He had contacted me and we had a conversation within the last month. But he hasn't contacted me as to why he's not here. He didn't, so I have no idea.
So ordered. And next would be Dylan Stanley, docket number 11.
I had a number for him that I had, gotten from him when he was here for his arraignment. That number's no good, so I've had no contact with him.
City wish warrant. Yeah. So ordered. So ordered.
Same thing with Mr. Jebediah Stecker.
He's not here. What a shock.
I know, I thought he'd be here early, but, yeah, so he'd give me a number. If the number's no good, I've not had any contact with him at all.
4 different matters, controlled substance, so ordered. Not a good thing when you're the entire page of the doc.
But it's all in the same year though.
It's.
I mean, it doesn't spread over
Good afternoon. Going to call the 1 o'clock arraignment calendar. The first matter I want to address would be Yelm versus Maria Alejandra Quinn. Mr. Mold, solemnly swear or affirm that you'll accurately translate from Spanish to English and English to Spanish all that has transpired here. Okay, thank you. And you have introduced yourself to Ms. Quinn. Good afternoon, ma'am. Is your full name Maria Alejandra Quinn? Citation alleges that on or about August 18th, 2024, you committed the offense of assault in the 4th degree domestic violence. Domestic assault in the 4th degree domestic violence. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I will turn to your attorney for the entry of a plea on your behalf. Do you wish a formal advisement of rights?
No, Your Honor. We've gone over her rights and spoken extensively about the alleged offense. Your Honor, at this time, we're entering a plea of not guilty.
I presume that there will also be a motion to quash a warrant that I issued a couple of days after the citation. There was reported violations of, I had originally entered simply conditions of release, no contact. It's the usual. And didn't enter a formal no contact order at that time. One is, I understand, has been subsequently entered by the alleged victim in the matter.
A civil order, Your Honor?
Yes.
Yes, Your Honor.
Motion to quash granted.
Thank you.
Plea of not guilty entered. We'll set the matter for a pretrial.
Your Honor, just to make a record, Your Honor, we have requested an interpreter. Ms. Quinn is very proud of her handle of the English language, but when I have tried to talk with her about the legalities of the situation, I find that she often gets lost. And-
Perfectly understandable. I have a fairly good grasp of Spanish myself, but if I was in trouble in Spain, I would have an abogado and I would have an interpreter. No question about it. It's
If we're to have a pretrial, will the court allow a 3.4 appearance so I could cancel the need and the
Yes.
cost of an interpreter in advance if we know she's not needed?
yes. Available September 12th, 26th, going into October 10th.
12th, Your Honor.
September 12th? Acceptable to the city? That's being prepared. Conditions of release, law of any behavior, no contact. I did do a civil standby in the conditions of release, may return with a Yelm police officer to retrieve personal effects, but those remain unchanged. If you want to address those at this time, you can.
I know that there's a formal no contact order. Your Honor, just so you're aware, she did seek assistance for a civil standby, and I think because there wasn't a formal order, she was told she didn't need assistance. And probably the language barrier also compounded that.
I would so imagine. The other conditions of release are stay in touch with your attorney and appear in court as directed. In the future, your attorney may be appearing by Zoom, but you should be here in person. Unless there's a request otherwise. Any questions at all? Resetting the matter to September 12th for a pretrial. Signing the order at this time. If O courts will let me do that. There appears to be. I am not able to, for some reason, it's sort of locked in on me. Something new every day. Cyber ineptitude. Sign today's order, and you can get a copy of that for yourself and your client at the window outside the courtroom and to your left.
Thank you.
Thank you, ma'am. Take care. Thank you, Ms. Quinn. Mr. French, I think you have a matter. Stewart, step forward if you would. And good afternoon, Mr. French. Full name, Travis James Stewart. Mr. Stewart, the citation I have alleges that on or about August 23rd, 2024, you committed the offense of driving while under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'll turn to Mr. French for a entry of a plea on your behalf. Stewart, a plea of not guilty preserves your rights pending a pretrial. We'll set that now with your attorney, September 12th, 26th, October 10th, 9 a.m. September 26th, Mr. Stewart, you weren't booked in. Conditions release are don't drive unless licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so. Stay in touch with your attorney and appear for court as directed. City, which anything further? No. Any objection, Mr. French? Okay. Currently signing today's order. Mr. Stewart, you and your attorney can get a copy of today's order for each of you at the window, and we'll see you back here at the end of September. Any questions at all? Thank you for your patience. Thank you for appearing. Docket number 5, I think. Good afternoon, Ms. Ganem.
Good afternoon, Your Honor. I'm here on behalf of Ms. Destiny Charles.
Okay, is Ms. Charles in the courtroom? Ms. Charles, if you'd come up and have a seat at the council table, we'll address your matter at this time. Good afternoon. Is your full name Destiny Lachelle? Counselor. Ms. Charles, the citation I have alleges on or about August 17th, 2024, you committed the offense of assault in the 4th degree domestic violence. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your attorney for the entry of a plea on your behalf.
Thank you, Your Honor. We will acknowledge receipt of the criminal complaint at this time. We waive further formal reading and ask the court to enter plea of not guilty to the charge.
Plea of not guilty has been entered on your behalf. That preserved your rights pending the pretrial, which we will set for Ms. Ganem, September 12th, 26th, or October 10th, 9 a.m. All.
September 12th works, Your Honor.
Signed it so. Signed that. Should be okay. I'm having that reload. Charles, any question at all? You can get a copy of today's order by going to the window outside the courtroom and to your left, and we'll be sending your attorney a copy of the order as well. Stay in touch with your attorney, abide any conditions of release set, and show up for court. That's it. Ms. Ganem, you wish to address any conditions of release at this time?
Yes. I'm assuming they are remaining the same for when she was initially seen in custody. We did want to address the condition of no contact at this time.
Okay, go ahead.
I believe when she was initially seen by Your Honor, she was in custody right after this incident, and the court, I think there were mental health concerns all around. The court did issue her release, but not before a DCR was completed. That was done, and she has it. I mean, without speaking too much about this specific incident, prior to this incident, she was in the hospital given some very strong medication, and that very likely had some involvement in this alleged incident here. She has, upon release from custody, she was seen by a hospital. Things were taken care of. She's having her health needs addressed. And so based on that, Your Honor, additionally, I believe the protected party is in the courtroom and can address the court. He's current military. He's been staying on base and has been in touch. I think the military is involved. He's been in touch with the Family Advocacy Unit to get resources and additional support.
Anybody wish to, Mr. Charles? Anybody wish to? Nobody's in the courtroom.
Oh, okay.
Maybe I take that back. I believe somebody just entered the courtroom. Mr. Charles, come on up. Your wife's attorney indicated that you might wish to address the court.
With regard to the no contact order, Mr. Charles.
I think based on the history, I'm not inclined to do that today. I would like the council for the city and yourself, Ms. Ganem, to discuss the matter further about that. There is some history here that I'd like the attorneys to discuss the matter before I do that. So I'm not going to at this time.
Understood, Your Honor.
Ms. Charles, I'm going to wish you the best of luck. You take care of yourself, stay in touch with your attorney, and we're going to readdress the matter at a future date, okay? Any question at all? That concludes the hearing. We'll see you back here September. Good luck. Donnie, I can't. Now I can. Tried this about 20 times. I tried to close it, it won't. Order is now signed. Full Courts is not my best friend today. Ms. Ganem, a copy should be in front of you or transmitted shortly. You take care. Thank you. Any other private counsel matters here? You're here for an arraignment. That's your first appearance after the issuance of a criminal citation. Before I call you up one at a time, I need to advise you that some very important things. You have a right to have a lawyer represent you at all stages of any criminal proceeding. Mr. Haverco, our public defender, will enter a plea on your behalf at this hearing and will represent you throughout the course of the case if you're indigent and request his services. Typically, a plea of not guilty is always entered at this hearing. It's no great statement about the case. That's the way your rights are preserved in a courtroom pending a pretrial. Pretrial is a chance for you to discuss your case with your attorney and to negotiate through your attorney, if possible, a resolution of the case. Sometimes that takes place, sometimes that cannot take place, in which case you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. If you have any questions about what you're charged with or what your rights are, ask Mr. Haverco or myself any question you might have. Caleb Almond in the courtroom. Mr. Almond, come up and have a seat if you would. Full name Caleb, middle initial E, Almond. Mr. Almond, you were cited with the offense of driving a license suspended or revoked in the 3rd degree. That's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. Now, there's a number of other people in the courtroom that have the same charge by itself, DWS 3rd degree. The city sometimes has a motion, and I see a nod at this time. The motion, and it is granted, is to reduce the charge from a criminal offense, which is what you currently have, to the civil infraction of no valid operator's license on your person 2nd degree. The difference is this: criminal offense, you're convicted, you can go to jail. Civil infraction, worst that could happen is a fine. That's since there's no possibility of any jail time, you don't have a right to have an attorney, and you don't plead guilty or not guilty to an infraction. You admit it or deny it. If you admit the infraction, I'll assess a fine in the amount of $150, and that'll conclude the matter. Now, do you have any question at all about what I just said? Okay, go ahead. I want clarity. $150 here, and this doesn't have any impact on your license. This won't resuspend or have anything to do with that. As long as you're making the payments on the fine and $25 a month, it's not going to impact your license at all. Does that answer your question? Maybe not. Go ahead. Okay, well, now, like I said, you have a right to deny that you committed any infraction. If you think you're wrongfully cited, tell me you deny it and we'll set it for a contested hearing. Okay, that's what we'll do then. Pardon?
I'm sorry. Let me play this.
I'm not, I can't understand you.
Let me just play it. Let me get it on.
Speak a little slower.
Just pay the ticket, please. I'm sorry.
We can do that, certainly. But apparently what I want you to do is check into this a little further. Yeah, I can, yeah, we can do that. I'll set it at 150 and you can pay it at 25 a month. But still, if you get stopped in the future, officer is going to see, you know, for whatever reason, your license is suspended and you're right back here. You don't want to be there. The records check showed Caleb's driver's privileges were suspended out of Virginia. For some reason in Virginia, you're still suspended, which means it's suspended here as well.
Right. I'm about to be done.
Okay, you're gonna get that taken care of? You live in a world where you've got to be able to drive, so that's a real good idea. I'm signing an order to that effect. If you have trouble making the fine payments, Mr. Almond, let us know. We can certainly deal with that. What I want you to do is go to the counter outside, get a copy of the order, and you'll know what you need to do. Good luck to you, Mr. Almond. Take care. How about Leonel Becerra Morales? Does not answer. We'll come back to that. How about Bambi Brittain? I don't see her. Ronald Carby. Jonathan Cordova Jimenez. Jimenez, come on up. Have a seat. Good afternoon, sir. Full name, Jonathan Steve Cordova Jimenez. Citation alleges that on or about August 14, 2024, you committed the offense of making a false statement to a public servant. It's a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Mr. Cordova Jimenez, we have not guilty has been entered on your behalf. We're sending a pretrial for October 10th, 2024. What I want you to do is get a copy of today's order at the window outside the courtroom and to your left, and stay in touch with Mr. Haverco. And be back here on October 10th. If you need to, need you to exchange contact information with your attorney.
512-661-6928. Okay.
Good over, that concludes the matter. I want you to go to the window, get the copy of the order, and we'll see you back here in October. Any questions at all? Good luck to you, sir. Sean Couch. Not up here. We'll come back to that matter. How about Cameron Curry? Curry, good afternoon. Now, you also were cited with the offense of driving a license suspended or revoked third degree. City may have a motion in that case, and the city just nodded yes. And the motion was to amend the charge to the civil infraction of no valid operator's license on your person. If you admit the infraction, it's a $150 fine. You can deny the infraction and have a contested hearing. It's your choice. If you admit the infraction and I assess a $150 fine, you can pay that. You don't have to pay that right now. You can pay that at the rate of $25 a month. First payment won't be due until September 29th. We'll dispose of it that way. Do you know what you need to do to get your license back? Yes. I'd make that a project. So, Mr. Curry, any question? I'm signing the order. If you would, go to the window, get a copy of it, look it over, and if you have any question at all, give us a call, okay? Take care of yourself. Thank you, Mr. Curry. How about Richard Gilbert? Richard Gilbert? Does not answer. Jack Julian Hood. Mr. Hood, come on up, have a seat if you would. Full name Jack Julian Hood. Citation alleges that on or about August 22nd, 2024, you committed the offense of theft in the third degree. That's a gross misdemeanor. Maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. Mr. Hood, I'm going to appoint Mr. Haverco to enter a plea on your behalf, and he'll do that at this time, and we'll set the matter for pretrial on October 10th.
Stipulate probable cause, Your Honor, ask the court to enter a not guilty plea.
Plea of not guilty, preserve your rights. I want you to exchange contact information with Mr. Haverco. The order that I'm going to electronically sign, it'll have his contact information on it. Stay in touch with him.
Okay, go see the clerk
Mr.
before you
Hood.
go, and she'll give you a copy of the paperwork.
Get a copy of the paperwork, and as I indicated, that'll have Mr. Haverco's contact information for you. Any questions? Good luck. See you back here in October. How about Dennis W. LeBleu? I probably mispronounced that. If I did, I apologize. That's a full name, Dennis W. LeBleu. Citation for you is the same thing as we've already addressed a couple of times. Driving a license suspended or revoked third degree. And by now you know what the city's motion is going to be. And that's to reduce the charge to the civil infraction of, I'll take that as an admission. And of course, the question is do you know what you need to do to reinstate your license?
Yeah.
Good idea. Live in a world where we've got to be able to drive. That's important. I'm signing the order. Payments $25 a month. September 29th is the first one. And again, if you have any trouble making the payments, don't let it go. Let us know, and we can deal with that fairly easily. Any question at all? Mr. LeBleu, go ahead and get a copy of the order at the window. And good luck to you in getting reinstated. Take care of yourself. David Lipscomb. Good afternoon, sir. Full name David, middle initial J, Lipscomb. And the citation alleges that on or about August 15th, 2024, you committed the offenses of operating a motor vehicle without ignition interlock when required to have that by Department of Licensing. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for driving a license suspended or revoked third degree, simple misdemeanor. Maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. Mr. Lipscomb, I'm gonna have Mr. Haverko represent you. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Not guilty, preserves your rights. We're gonna set a pretrial for October 10th, 11 a.m. That'll be in the order here.
Give me your number again.
Lipscomb, don't forget to get a copy. Thank you, sir. Brittany, excuse me, Brittany Nicole Loper. Good afternoon, ma'am. Is that your full name, Brittany Nicole Loper? Ms. Loper, the citation alleges that on or about August 16th, 2024, you committed the offense of driving a license suspended or revoked third degree. Again, gross misdemeanor or simple misdemeanor, maximum of 90 days in jail and or a $1,000 fine upon conviction. The city, as you may have heard already a few times, typically reduces the charge to the civil infraction of no valid operator's license on your person. If you admit that, it's a $150 fine payable at $25 a month. Any questions about anything I've just said? What do you want to do? Do you know what you need to do to get your license back? Yeah. I'd work on that. The reinstatement fee always jumps up and hits people. Your first payment due to us would be until September 29th. Now, I want you to have your license. So if there's a problem making the payments, let us know, get back on the calendar, and we can deal with that. We can figure it out. You've got some pretty important little companions there. I want you to take care of them and be able to drive to all the different things that are necessary. Ms. Loper, get a copy of the order of today's hearing at the window. And any questions? Take care of yourself. Miguel Martinez. Good afternoon, sir. Is your full name Miguel Valentin Martinez? That's, I'm gonna mispronounce the name if there's a way to do it. That's it. Citation alleges that on or about August 13th, 2024, you committed the offense of driving while under the influence of intoxicants. Gross misdemeanor, the maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko to enter a plea on your behalf, and he will do so at this time.
Stipulated probable cause, ask the court to enter not guilty plea.
Plea not guilty is entered on your behalf, Mr. Martinez. There's also some 3 infractions. We'll calendar those right along with the criminal offense. Court date will be October 10th at 10 o'clock. And that'll be in the order that I will sign in a moment here. And of course, again, no drinking and driving, no criminal law violations. Any officer asks you to take a breathalyzer, do so. And stay in touch with Mr. Haverko and be back here on the 10th of October.
Two zero nine seven.
Martinez, thank you for appearing. Don't forget to get a copy of the order at the window. Take care of yourself.
Thank you, Your Honor.
Albert, Nabalta does not answer. Austin Parker. Full name Austin Lewis Parker. Mr. Parker, the citation alleges that on or about August 25th, 2024, committed the offenses of driving while license suspended or revoked in the first degree and operating a vehicle without ignition interlock. Those are both gross misdemeanors, the maximum penalty on excuse me, 364 days in jail and or a $5,000 fine. Mr. Haverco will enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty, please.
Plea of not guilty preserves your rights. Mr.
Yep,
Parker will
yep,
set
phone
the
number.
matter for a pretrial on October 10th, 11 a.m. Order is now signed. Mr. Patton, condition of release, of course, is don't drive unless licensed and insured. And stay in touch with Mr. Haverco and be back here for court on in October, okay? Take care of yourself. Michael Patton does not answer. Arnold Ramirez Cipolito does not respond. Nicole Saunders. Cody Shaw. Nicholas Civic. Emmanuel Webster. Good afternoon, sir. Go ahead and have a seat. Full name Emmanuel Lewis Webster. Mr. Webster, the citation alleges that on or about July 20th, 2024, you committed the offense of theft in the third degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and a $5,000 or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and represent you in this matter.
Stipulate
Haverco?
probable cause, ask the court to enter a not guilty plea. Yep, phone number.
Webster, I've now signed the order. Get a copy of it at the window outside the courtroom to your left, and you take care of yourself, okay? Your next court is, let me go back to, it'll be in the paper, and it's October 10th, 11 o'clock. That'll be on a Thursday. We'll see you then. Take care of yourself. Stay in touch with Mr. Haverco, and thank you for your patience. Trenton Woodard. Trenton Woodard does not answer. How about Gary Woods? I'm out of names, but I'm not out of people.
We can take up Mr. Ray Bellman.
Mr. Ray Bauman,
On the
how are you?
945.
And ma'am, are you here for court? That happens. Mr. Ray Bauman, how are you? I'm sorry to hear that. That's I really hope so. It's,
Working. There you go. Mr. Ray Bauman just signed a statement of defendant of plead guilty. I anticipate he is going to enter the guilty plea to one count of criminal trespass. Second degree, and upon the court's acceptance of that plea, the city will move to dismiss the other 3 counts. The recommendation is all suspended jail time for the next 12 months. Don't commit any criminal law violation, and then the case can be closed. The city was not asking you for any financial obligations.
For the record, full name, John Ray Bauman. That's I'm looking at a statement of defendant on plea of guilty to 1 count of criminal trespass, second degree. That's a simple misdemeanor. The maximum penalty, 90 days in jail and or a $1,000 fine. If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to the max, 90 days or 1,000 if I saw fit, regardless of the recommendation. You realize that. As to 1 count, criminal trespass, second degree, alleged to have occurred in Yelm on May 30th, 2024. How do you plead? Guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy that actual elements. City, have anything to add? Mr. Havercoat, anything?
Nothing to add, Your Honor.
Sean, anything you'd like to tell me? You don't have to say anything, but I'm all ears if you got anything you want to tell me. Alternate 90 suspended on the condition you have law-abiding behavior. You know, hey, you're here. That's better than you usually do. So I'm glad to see you. All right. That's don't give up. There's always hope. Don't give up. And it looks to me like you're kind of wavering a little bit there, and I don't like to see that. What now? I'll take up a collection and buy you a watch or something. So that might be a start in the right direction. I'm gonna look into that. That's, as I said, you're here, and that's a step in the right direction. Sign in the paperwork, Sean. I want you to get a copy of it at the window and look it over, and any question at all, we're here. We're here. I want to thank you for showing up and your patience, and wish you the best of luck. You know, that's can't do any more than that. You take care of yourself and hang in there, okay, Sean? Okay. Take care. Ma'am? Come on up and have a seat if you would. I didn't catch the name. What's your last name? And I think, well, he was on. Should have recognized you for the Bambi Angelique Brittick.
Sorry.
Your full name is Bambi Angelique Brittick. Citation is driving a license suspended, revoked, third degree. That's simple misdemeanor, and the city usually has a motion in that case and is so moving here to amend the charge to no valid operator's license. Put it in your. It's now, you all set? It's now a simple misdemeanor, no longer. It is a civil infraction. If you admit you didn't have a valid license on your person, it's a $150 fine. You can deny that. You know what happens a lot is people move and then they don't let Department of Licensing know they've moved, and so you never get a notice. But what would happen is, yeah, what we're dealing with here is, did you have a license or not on August 16th when you were cited? Now, I want you to get your license back, and no matter what happens here, this is not going to suspend your license. It doesn't have any effect on it. If you admit it, it's a $150 fine. If you deny it, we can set it for a contested hearing at a later court date. We can do that. What would you like to do? I don't think it wouldn't change anything here. That was, if you want to think about it, we can just give you another court date. Or you just want to get it done with, or do you know what you need to do to get your license? You know what you need to do to get your license back? And it snowballs on you. I'd work on getting it reinstated. Do what you can, okay? Do what you can to get your license back. And the order today, you can get a copy of that at the window. All right, should I repeat myself? I've signed an order. You can get a copy of that at the window outside the courtroom and to your left. Ms. Britton, thank you for appearing. do have a couple of civil hearings at the end of the day. One of them does involve an attorney, Taylor Link or Linky. Mr. Linky, this has been going on for quite a while. You do have an attorney of record, Chris Langley. Is she gonna be here? What's the situation?
I don't know. I reached out to her via text message and calls, but I haven't heard back from her. She was supposed to be here. I'm not sure.
Hey,
I really don't want to set it over again either.
that's. That is kind of a difficult position that I'm in. What would happen is what I would be ordinarily want to do was to reduce the amount of the fines and put you on a payment program, is what I would want to do. I'm sort of a little bit reluctant to do that without your attorney here. She's still your attorney of record, and it's kind of unethical for me to go ahead and proceed without her say so. So I'm kind of in a difficult position here.
Well, the last time she was here to represent me, I didn't come in, but she had said that I gave her proof of my insurance, stuff like that. And she said that whatever judge was here at the time wasn't good enough because it was digital, I think. And I printed those off today and brought them to the court to at least get those off, because those are the heftiest fines.
So look, I hate to do this to you, but that's the way the law is structured. I can't hear the case as long as she's your attorney of record. She needs to appear or withdraw or something. I really don't have any choice but to reset the matter. I don't want to address it without her say so. I don't agree with that. But I really don't have any choice. So but to reset it.
Can I submit my paperwork to the court at the minimum today?
Do you have I do have some paperwork here, but if anything you have.
Look, that's the same one I have. She printed them off too then.
That's if you have anything to file, you can certainly file it
No,
at
it
the
looked like
window.
you had the same one.
But this might be it here. But
That's
no,
an insurance card right there on the front, right?
it's yes.
Okay,
Insurance ID card, Washington.
yeah.
Gold Plus level valued customer. That's it. Yeah, I'm in a position where I can't really do anything today, Mr. Link. That's
Yeah, I'm not sure. I wanted to just come out and say I fired her, but I would like to. How long would it take for you to set it over?
the 12th. That's the next court date.
September?
12th. Yep.
Okay.
September shows up. Gosh, where'd August go? The Sunday, September.
Yeah.
Where do the years go?
Okay, that's all right, I guess. We'll go to the
September
12th.
12th. Yeah, it's
All right.
much more comfortable doing it that way. It's
Okay. Thank you.
Mr. Link. Feel like apologizing to you for gosh sakes.
On the 12th, if we have a issue with anything, can we move forward then, or what do we?
If she withdraws or you fire her, that's yes, we can.
Okay. I'll give it a go one more time and.
Please.
Okay.
Donnie, do we need a notice or? Oh, there's a notice. So Link, if you. Do I need to just send it up to go to the counter and? There's a notice of a hearing. There's no signature required by me. Mr. Link, if you go to the counter outside the courtroom to your left, they'll give you a copy of the notice with the date and time on it.
Okay, perfect. Thank you.
Mr. Link, you take care of yourself.
You too.
See you in a couple of minutes. Christopher Sponberg. There you are. He asked for a contested hearing with regard to a citation issued to you for neg 2, negligent driving in the second degree. Contested hearing puts the burden on the city of proving by a preponderance of the evidence that the infraction was committed. There's a lot of ways of explaining that. Scales start evenly. If they tilt a little bit in favor of the city, I'll rule for the city. If they tilt a little bit in favor of you, I'll rule for you. The scales don't move at all. No burden has been met. I'll dismiss the ticket. There's one other option, and that's called a deferral, which is a sure way of keeping it off your record. Every court does a deferral a little bit differently. In this court, hold the matter for a period of 4 months, set costs in the amount of $150. If you attend traffic safety school, that's an online program that costs $40 and it's a couple of hours. And don't get any more citations over the next 4 months. The ticket is dismissed, it goes away. Just to let you know where I come from on these things, the face amount of the ticket is $559. If I ruled in your favor, I haven't read the case, so I don't know anything about it yet. Shouldn't. That's if I find in favor of the city, I'll dismiss the ticket. That's you walk out of here on nobody, nothing. But if I did find that you committed the infraction, I'd hit you for $150 anyway. I wouldn't hit you for $559. I'd hit you for $150. And of course, truism to say what we're talking about here is not necessarily a civil infraction, but it's insurance premiums. Is what we're really doing. Any question about anything I said? It's kind of your choice whether you want to go to a contested hearing or defer it and get it dismissed. Any questions about it?
I'm not really sure. I just wanted to come in because the cop didn't have any proof that I was speeding, and he told me that. He said that he never caught me on radar and it was just off of his judgment. So, and when I talked to him, I was very apologetic, and I said that I was, very sorry that I didn't, that I came around a corner too fast, but I said that I drove those roads my whole life. There was no way that I was flying down the road because it was back on Canal by Lasco. But
no, if he had cited you for speeding, that's yes, I would want a reading and a admissible 6-6 affidavit with regard to the accuracy of the radar device. The negligent driving, it doesn't require any particular. You could be going negligent driving. I've seen people cited for negligent driving when they're driving 5 miles an hour in a 30.
okay,
It just depends on the situation. Children running back across the road, icy road, et cetera, et cetera, et cetera.
okay,
So I don't know what the specific situation was here, but whether you're speeding or not, or exactly how much you were going over any speed limit, whatever it was, that's not necessarily important.
okay.
So
Well, then the deferral would probably be best, I would think.
that's you're entitled to one deferral for a moving violation every 7 years and one for a non-moving violation every 7 years. This is a moving violation. However, a lot of courts, never had it really come up here, will amend a moving violation to a non-moving, so you can use a second deferral. But yeah, we'll defer it, $150 to be paid within 4 months. Traffic safety school, I think we can give you the information on that. Monitor the record 4 months later. If you're in compliance, ticket dismissed, goes away.
Awesome, thank you, sir.
And I always tell everybody, driving a car is probably one of the most dangerous thing, if not the most dangerous thing you're ever going to do. And there's too many idiots out there.
Oh, yeah.
I go up to Bellevue at least every other week.
I got 3 daughters and one's about to be driving, so I'm on my best behavior.
Oh yeah. Oh boy.
Oh, yeah. 3 daughters too.
Insurance,
Yeah.
the biggest scam there is.
Yes, sir.
Signing an order, the effect of today's hearing.
Now, do I have a little bit to pay that 150, or does that due today?
Oh, no, 50 a month, first payment, September 29th.
Oh, okay,
20
perfect.
Beginning December 29th. So you don't, yeah, that's It all needs to be paid by then, but in any particular order,
Okay.
not today.
Okay, perfect. Thank you.
Signing the order electronically. Now you can get a copy of that at the window, outside the courtroom to your left, and happy motoring, relax out there, take it easy, watch out for the idiots, that's, and in your own enlightened self-interest, keep the insurance premiums down.
Absolutely.
You're gonna need that here before too awful long.
I know, thank you for that. Appreciate it.
Take care.
All right. You too.
Now, just go to the window and help you out. You too, take care. Back on record for the 1 o'clock no shows. The first one I have is docket number 2, page 14. Lionel de Sarah Morales, Diego third, amend to Noval 2 and FDA. The next one would be Ron Carvey, docket number 4, same thing. DWS third, amend to Noval 2 and FTA. Next one I have is Sean Couch. Docket indicates he doesn't have it right, but he would like a payment program. Just give him a payment. Amend it to Noval 2. 150 and whatever works out best for him payment wise. Next would be Richard Gilbert, same thing, DOS third, amend to Noval 2 and FTA. Well, Albert Nabalta, same thing, amend to Noval 2 and FTA. Same way with Michael Patton, docket number 18. Noval 2 and FTA. And on Maria Quinn, make sure that warrant gets washed. That brings me up to Arnold Ramirez Polito. It's I find probable cause for false statement to a public servant. And then the second charge, DLS third and no ignition interlock. That looks like a cash bail that was posted. And it was posted by his relatives, one of whom he used as a false name. But find probable cause for each of them, 2,500 each, cash or bond. Yeah, that was his family that, oh well. Nicole Saunders, is there a dismissal order in O courts? I was gonna check that I didn't. If not, without prejudice. Yeah, that was the one where it was very late filing. And it was just somebody in crisis anyway. It's like, not real. Definitely without. If they want to refile it, they can certainly do just that. Refresh. Got it. Signing. Boy, that business with the, when I couldn't sign it because it was in Spanish and English. So that was an interesting. Oh, signed and closed. Cody Shaw, probable cause previously found when he was booked into jail. 1,000 cash. And Nick Sivich, DLS third, amended Noval 2 and FTA. Trenton Woodard, man, he is the one that 25,000 cash or bond. That's don't know who paid for that bond. Forfeit the bond. Probable cause is previously found for harassment, DV. New warrant, 75,000. Last is Gary Woods, and that's a DUS third, and then to Noval 2 and FTA.